Hi Joe.
Hey Rebecca.
So today we are going to talk about a significant decision of the Federal Court that was handed down last Friday. It's fair to say that this decision has generated a lot of discussion.
There's a lot of commentary occurring, a lot of opinion on what it means, but I think the decision itself is fairly clear in terms of having an implication for the use of annualised salaries. I'll make the distinction that we're talking about annual salaries for award-covered employees versus employees to whom an annualised wage arrangement applies, because that's quite different and not all awards allow it. Some do, and there are very clear parameters of how you can make this work. This is talking about a salary for an award-covered employee that provides a set-off for other conditions within the award.
I think that's a really important point, Joe, because every case obviously turns on its own facts and particulars. We're talking here about employees covered by the General Retail Industry Award,
Yes.
which does not contain an annualised wage arrangement clause. I think that is really important. So employers who have employees receiving a salary under an award that has an annualised wage arrangement clause need to pay attention.
Yes.
There are still some relevant findings, but doesn't necessarily have the same sort of implications.
I do agree with you. I think employers need to be mindful of the precedent this sets and really focused on the annual salary and the use of the set-off clause and the operation of the set-off clause. But what Justice Perham did in the decision is that he has reaffirmed the position that the Fair Work Ombudsman has taken for a period of time. So it's key to reaffirm, to give authority to that position. It's worth thinking about what this means for any annual salary that's being paid to an award-covered employee. How is the set-off written? Is there a set-off?
Yeah.
And we talked about that in an earlier vlog, the importance of employment contracts. Let's review them. Let's look at how this could have an implication. But certainly I think if it's not appealed and it stands, there'll be a bit of work for employers
to do. Yeah, look, absolutely. Let's dial that back and just sort of establish what we're talking about in plain terms. An offset clause is a fairly typical clause in an employment contract that effectively says that what we pay you by way of an annual salary or remuneration will satisfy all of the obligations we might otherwise have to pay you under an award for ordinary hours, overtime, breaks, allowances, penalties. The clauses don't always say that this is over a period of time. The Woolworths clause sought to say, oh, this is over 26 weeks. The Coles had 5 different clauses which all sought to do the same thing but didn't necessarily apply it over time. But the common approach in applying those clauses has been to say that the annual salary will even out the peaks and troughs. There's 1 week you might not do any overtime and you're going to get the same salary that you will receive the week that you do work overtime. And so it's premised on the basis that you're always earning across the whole year what you would have otherwise been earning if you'd kept a timesheet, claimed overtime, been paid overtime. The traps, and obviously the one that Woolworths and Coles have fallen into here and many other employers, is that there are very strict payment obligations under the Fair Work Act, in particular that an employee is entitled to be paid in full. Now what this decision really clarifies and, as you say, provides some authority for the proposition that the Fair Work Ombudsman had always taken is that the obligation to pay wages under the award, where specified, will be a particular pay period. Usually fortnightly, many of them are fortnightly, some of them can be monthly by agreement, some of them are weekly, but by and large it's fortnightly. So where you've got an award on the one hand saying employees must be paid wages fortnightly, let's say, and on the other hand you've got the Fair Work Act saying employees must be paid in full, what Justice Perham has ultimately done is clarified that payment in full must occur in each pay period. And you can't make up for an underpayment in pay period 1 by an overpayment in pay period 2, which is effectively what an annual salary does across the year, let's say, a 12-month period. What I think is interesting is that the annualised wage arrangement clauses in those modern awards where it does appear does permit that. It actually expressly says that provided the employee gets paid what they would have under this award over 12 months, then the annualised wage arrangement will be, they'll be no worse off, or there'll be no disadvantage. Now, obviously, that test does not apply here, but it's clearly not outside the contemplation of our industrial relations system that that's okay. The problem is, obviously, here we don't have that particular permission in the awards that were under consideration here.
And I do wonder whether we might see some reform in this area for annualised wage arrangements coming out of this decision.
Look, I think that's highly likely, whether it goes on appeal or whether there's some legislative intervention, but there does need to be some reconciliation between those two different positions, because there's no real common sense reason why someone on the retail award is not permitted to have their wages annualised over a year, but somebody on the clerk's award is. There's no sort of fundamental underpinning rationale for that difference, except the absence of those wage arrangement clauses. Now, I know, Jo, that you're familiar with some of the considerations that came into play in the four-yearly Modern Award review that considered annualised wage arrangements in awards. What insight can you share around what might happen as far as reform goes?
So the annualised wage provisions in modern awards, they were the subject of quite a lot of scrutiny at the time as part of the four-yearly review. There were a number of awards, around 30 I think it is. Not all annualised wage clauses are the same, so some are quite different, and the requirement for outer limits, for inner limits, for overtime, you really have to look at what the award provides. The premise of them was to allow an arrangement to effectively streamline payroll processes, make it easy for employers, recognise the type of roles or the seniority of those roles for that purpose, but still require reconciliation. So one of the awards, the Hospitality Award, I was involved in the proceedings for that when I was working at the AHA. We advised all of our hospitality employers to keep track of things, so to essentially make sure they were keeping track the whole way through, but they would have to reconcile it at the end of the period. This decision doesn't necessarily give that scope to Coles and Woolworths. In fact, it says that whatever you were planning to do over the 12-month period doesn't take away from the solo pay period. So I wonder whether we might see annualised wage conditions, some employers look at them a bit more closely to say, is this something that we need to do? Are we going to see them change? Now, look, I wouldn't be surprised to see some sort of proceeding commenced, whether it's a Fair Work Commission by their own initiative or groups
an
making
employer organisation
or unions making an application to clarify the annualised wage provisions or to preempt potential reform in that area. Or it might actually form basis for the appeal to say, well, hey, we can't have two different arrangements.
Yeah, that's right.
I think there's a lot to be, there'd be a lot of parties contemplating what they'll do.
It's not hard to think about the different directions this could go in, is it?
Yes.
I mean, You know, you just mentioned there the possibility of an own initiative or an applicant proceeding in the Fair Work Commission. Is it possible that this decision would be the basis for an argument that the annualised wage arrangements in those awards that do have them are unlawful, in the sense that they provide for a 12-month reconciliation? Now, that doesn't sit with this decision.
No, it doesn't.
But that might be a basis to say that term of the award's unlawful because the entitlement to be paid in full is in each pay period. So watch this space on that. The other thing that I think too is interesting is the intersection between this issue and the recent legislative amendments that were made that will, and you raised this point in a discussion we had earlier this week in the office, the prohibition now in place on removing or watering down, or however you want to frame it, overtime and penalties will come into play directly in consideration of any revisions to awards around this issue. And it remains to be seen exactly what that impact will be. Those who are in favour of these arrangements would say, well, the no disadvantage test, which is in those annualised wage arrangement clauses, would overcome that any issue or concern that penalties and overtime would be lost. And I think that's a reasonably good argument. But again, those discussions and arguments, I think, may need to be had.
Yes, well, annualised wage arrangements aren't impacted by that penalty rates reform, but this decision may very well have that impact. And it may be that we see those clauses being amended so the reconciliation has to occur every pay cycle.
There are some other aspects of the decision that are worth discussing, and we'll come to those. But when you think about why employers choose to implement an annualised salary, it's usually for convenience of both employer and employee, but principally it's easier for an employer to manage payroll, to manage record keeping if they've just got an annual salary. It's always premised on the basis that the salary is sufficient, but that needs to be able to be demonstrated and tested, and that's where employee records come into play. But you've got to ask yourself, and you mentioned it before when you said, will employers have to run pay cycle reconciliations? There were a number of suggestions on LinkedIn about what the practical implications were. What advice should we be giving employers about what to do? And one of them was, well, you should run a shadow payroll cycle every fortnight.
Yes.
Now, running a payroll cycle every fortnight is hard enough for many, especially large employers. I think running a shadow one is a good suggestion as far as mitigating this risk, but impractical. So you find yourself then saying, well, why bother? Why bother paying your employees an annual salary? Why not just pay them an above award rate and get them to keep timesheets and submit them and run, you know, a normal sort of back to basics, no frills payroll system? I think that question comes up. What do you think about that?
I think it will impact potentially on flexibilities. And it will impact on convenience for employers. It will be a question that employers will ask, why would I do an annualised salary? But you've hit the nail on the head in terms of the record keeping, because that was a focus of this decision, which was, just touching on one point, asking your employees to keep records and using clock in, clock out. The employer needs to take more of a role when it comes to making sure it's being utilised properly. So there are lessons here for employers in terms of actively managing work hours, records being kept, time clocks being up to date. And that's something that, you know, from all layers of management, we need to take more of an active role to ensure that the records are sufficient, the records are kept as they're actually required to under the Fair Work Act and the regulation. Absolutely.
The record keeping obligation, we all know about it. We know it's been there. We know that there's a presumption that an employer would have to rebut in relation to underpayment claims if those records don't exist. So there's already enough impetus for employers to keep those records. But I think what was really useful here is that Justice Perham said it's not enough to be able to say, well, here's the roster and here's the clock in, clock out record, And from those taken together, you can deduce when the person worked, when they took a break, and from that you can then deduce what their entitlement was. So the record keeping really needs to go further and be able to demonstrate clearly, so-and-so started at X time, worked so many hours ordinary, so many overtime, had this break, got this entitlement to a penalty, etc., and how that's calculated, so it's more explicit. Now, I think we've got the technology for this. That's the other element of record keeping. Lots of apps, and companies like Woolworths and Coles build their own, so there are ways, I think, to alleviate the administrative burden of collecting the information and then creating the record that you need to keep, and AI probably has a role to play in that. So I don't think the record keeping obligation is sort of new or imposes some kind of new, more onerous obligation, but it does clarify that the implications of not complying with that record keeping obligation don't go away. It doesn't get any easier for employers.
And I think that's the aspect where employers will need to be more vigilant. So what happens in the situation of the employee who forgets to clock off? We can't make up a roster. We can't assume that they're left on time. So there's the human side, which is the discussion. Hey, when did you finish? And checking that and verifying those timesheets. So the human aspect, maybe for some employers, this will be
a full-time job.
Yes.
For somebody. Some lucky person.
Yes.
Yeah, look, absolutely agree, Jo. The other thing too is for employers to be aware that if you're paying your employee who is award covered a salary, that doesn't diminish or remove or exclude the requirement to keep those employee records. There is a suggestion in some comments of Justice Perham in the decision that if you're paying sufficiently high enough, you probably don't need to worry, but I don't think there's any comfort in that. I think you've got to be able to run the calculations at some point and demonstrate at all times that you are paying sufficient to cover that liability under the award. Moving on then to another aspect of the decision that was useful, it's in the sense that it provided some clarity and direction where there has been limited clarity on this point. And I know we've considered this for some clients previously, and that is it's not uncommon for an award provision to say that an employer can agree with an employee or a majority of employees to something other than what the award says. So for example, the award might say the maximum ordinary hours per day are 8 hours, but an employer can agree with an employee or the majority of employees that the maximum daily hours will be 10. And so what came into question here is, well, how do you demonstrate that you've reached agreement? And what is not uncommon for employers is to say, well, I've published a roster that said the shifts will be 10 ordinary hours, and the employee worked the roster and that agreement was implicit. Or I circulated the roster and there was a tick box that said I agree, and so agreement has been reached. What Justice Perham effectively said is that's not enough. So the onus is on the employer to demonstrate that the employee knew and understood the entitlement that they would have been receiving in the absence of that agreement and agreed to forego that. And so again, that administrative burden, particularly part-time employees, where it's not unusual for an employer to seek agreement for the employee to perform hours that are additional to their rostered or guaranteed or minimum, whatever you want to, whatever the award calls it in any given situation, and whereby agreement those hours don't become overtime until the maximum weekly hours are exceeded. Now, demonstrating that agreement is usually done by a tick box or by an acceptance of a roster. This decision says that's not enough. You have to demonstrate your employee knows what they're giving up essentially through that agreement.
Well, what we're doing is bringing back good old-fashioned communication.
True, that's true.
It's the intention to have that communication that I think is the key in so many aspects. The records, the changes to the awards using the facilitative provisions. Yes.
Exactly. Well, that's exactly what has come into focus is how do you affect those facilitative provisions, or how do you demonstrate you've got agreement about those?
Yes.
And where you're seeking to agree with the majority of employees, does this mean you've got to take a vote, a formal vote? You know, how else would you demonstrate that the majority of employees have agreed? Because what that also infers is that some employees didn't agree, but you're imposing this on them anyway because the majority did. And so there's scope there for employees who are unhappy with that to really challenge the notion.
I think that's a really good point, because if, you know, with the onus being on the employer to rely on that agreement having been reached, a vote or a ballot is a much more robust way to show the agreement was reached, rather than just put up your hands and counting.
Yes,
the
exactly.
people. So the employer's got quite a bit to think about.
Look, there is a lot to think about, and obviously the implications for non-compliance are still very serious for employers. I mean, these were Fair Work Ombudsman initiated proceedings, which were then sort of piggybacked by some individuals who were leading representative and class actions. So the appetite for pursuing these types of contraventions is there, not going to go away, particularly for unions who are probably seeing themselves as incentivised by the notion that they may be awarded civil penalties, as we saw in the Qantas and TWU decision. So it's not going away, it's not getting easier. Subject to an appeal, this is what we've got to work with in terms of advising our clients, and that's the tricky part, is what's going to be the right solution. And we are solutions orientated people, Jo. We want to be able to go to our clients and say, it's all very well that there's this interesting decision and the lawyers are all in a frenzy about it, but what do you need to do now?
Yes.
And the answer to that question can be different for different organisations.
Absolutely.
It can be different depending on the nature of their workforce, the award coverage, their appetite for risk. There's a range of things that come into play there. You've, as a solutions orientated person, you've flagged with me in discussions we've had that IFAs might also really come into the fore here.
Yes.
Do you want to talk us through how you see that panning out?
Yes, well, I think all awards have the ability for an IFA, the Individual Flexibility Agreement. The provisions in awards are limited to how you can utilise them, but they might be the way in which employers can look to building conditions into over-award payments, the frequency of the payment, notwithstanding all of the award conditions still being met. So it may be on an individual basis. There is the ability to look at how that might achieve some flexibility and some administrative ease from a payroll perspective. That's yet to be seen, but I certainly think there's some possibility there.
Yeah, it just got me thinking about, you know, those provisions around IFAs and what employers are permitted to tweak and what they're not permitted to tweak. One of the things that Justice Perham said is he didn't think that contractual offset clauses could actually ever really work the way that people want them to, and perhaps essentially because of the combination of the Fair Work Act obligation to pay in full and the award requirement to pay fortnightly. But IFAs may be a way around how you arrive at what's due in full each fortnight.
Well, it might also give some scope to look at extending the pay period out to a monthly, so that you're reconciling it over a month rather than a week or a fortnight.
Yeah. I think we should do some real-time research actually, because it would be very easy to quickly determine whether the clause about payment of wages is a subject about which an IFA can be made. I'll go have a quick look.
Yeah, look at.
The IFA can't vary when payment is made, but because it can vary like overtime and other things, it can obviously vary what's payable every 2 weeks.
Of course, the underlying requirement of an IFA is that the employee must be better off. So there is that guarantee that there will be some element of checking or reconciling to ensure that similar to annualised wage provisions. I think it's an interesting one.
Remains to be seen, doesn't it?
But I do think a bit of a test case to see how that could work. Could be on the cards.
You know what I think this also sort of flags for us, particularly for people like us who do a lot of work in enterprise agreement drafting, and that is what are the agreements saying about the pay period? I don't think it's comes up often, if at all, as a boot issue if an employer seeks to vary the frequency of pay. And it's not something that's really had a lot of focus, but I think what this decision does is bring it right to the fore. And it may be that we're also revisiting some of the agreement terms to look at what the implications might be there.
I don't recall any agreements where we've sought to change the pay frequency that went above and beyond already specified award timeframes, but it could be interesting.
Well, it's certainly achievable on the basis of a better off overall test. If the employees are paid sufficiently high rates that they're better off overall, then timing of the payment may become less important as a factor, have less weight. Anyway, something for us to be thinking about when we're drafting.
I mean, what the decision does is it's a bit of a contradiction between pay cycles and averaging arrangements. And averaging arrangements, when overtime for casuals was brought in a number of awards not that long ago, there are some awards that say casual overtime, you're looking at an average of up to 38 hours over a 4-week cycle.
True.
And that award might provide that pays on a weekly basis. So I've fielded a lot of queries about how that interacts with each other. So this decision, what does that mean for those averaging arrangements? And therefore...
I think that's a bit of a sleeper issue, Jo. It's a really good point. It conflicts with, on face value, award provisions that permit you to average somebody's hours over 152 hours over 4 weeks, up to 152 over 4 weeks. So it's in many respects, disappointing that we do have to field these queries because the degree of uncertainty that employers experience, and especially those in payroll, is making it increasingly difficult.
Yes, sure is. So it'd be interesting to see in the next couple of weeks what happens in terms of appealing this. I can't see it not being appealed.
I agree.
It's too significant a case not to be robustly, challenged and determined. But for the moment, there's a bit to be getting our heads around in terms of what could be the implications moving forward.
That's right.
And the value of the annualised salary. Really. Not forgetting the fact that there is that guarantee of an annual remuneration in the Fair Work Act. So that could be a consideration for those employers that have more senior employees covered by an award where they can provide the guarantee of hours.
That's a good point. Absolutely. There is certainly, you would certainly be very upset if you were paying an award-covered employee, and some award-covered employees are very senior. You'd be very disappointed if you were paying them above the high income threshold, and yet pay period to pay period, there could be an expectation that you top up. So for anyone with that situation, check the contract, make sure that there's a guarantee so that you can rely on that to say the award conditions don't apply. That's a good point. And the operation of the annual, the guarantee of annual earnings obviously needs closer attention in terms of employers ensuring that they're actually implementing those in accordance with the provisions of the Fair Work Act. Lots to think about, lots to do. Our job is to help our clients keep up. Thanks for your insights, Jo.
Thanks, Rebecca.
See you next time.